Hello, good morning. Welcome to this lecture series on the law on criminal procedure. This afternoon, we are going to discuss about some portions on preliminary investigation, and thereafter we will go to arrest. So let me share my screen with you. Okay, so again, before we proceed to arrest, let me just go over some of the more important portions about the discussion on preliminary investigation. We will go to the process. Now, let us go to the resolution of the investigating prosecutor. If the investigating prosecutor finds cause to hold the defendant for a trial, he shall prepare the resolution and information. So, class, this is the output in a preliminary investigation. After the submission of the parties of the complaint affidavit and the submission of the defendant or respondent of the counter affidavit. Now, if the complainant wishes to file a reply affidavit, that can also be allowed by the investigating prosecutor. And then the last affidavit to be filed is what? A rejoinder or a reply affidavit. So, complaint affidavit, counter affidavit, rejoinder affidavit, and then reply affidavit. Sorry, rejoinder affidavit and then reply. No, so that is the order. Now, after the submission of these affidavits, the investigating prosecutor will prepare a resolution and information if he finds reason or grounds to hold the respondent for trial. Now, the investigating officer under oath shall certify the following: that he, as shown by the record as an authorized officer, has personally examined the complainant and his witnesses. This is the duty of the investigating prosecutor. No? He shall examine. He shall personally examine or interview or raise some clarificatory questions or probing questions to both to the complainant and his witnesses. And the number two, the resolution shall also certify that there is a reasonable ground to believe that the crime has been committed. Third, that the accused or respondent is probably guilty thereof. Fourth, that the respondent was informed of the complaint and the evidence submitted against him. And number five, that he was given an opportunity to submit controverting evidence. So these are the certifications to be made by the investigating prosecutor. Now, within 5 days from the issuance of his resolution, the investigating prosecutor, now that there is a finding on the part of the investigating prosecutor to hold the respondent for trial, what the investigating prosecutor will do is to forward the record of the case to whom? The provincial or city prosecutor or chief state prosecutor, or to the ombudsman or his deputy by the Sandigan Bayan in the exercise of its original jurisdiction. Now, in case that the investigating prosecutor find ground or reason to hold the respondent for trial, what he will do is to prepare the resolution. Now, within 5 days from the preparation of this resolution, he shall forward the record of the case to the higher authority. Who is the higher authority? It can be the provincial prosecutor, or in cases of cities with their own prosecutors, then the city prosecutor, or it can be forwarded as well to the chief state prosecutor or to the ombudsman or his deputy in case of cases cognizable by the Sandigan Bayan in the exercise of its original jurisdiction. So these are the higher authority than the investigating prosecutor. Again, the investigating prosecutor will prepare the resolution, meaning what are the conclusions, what are the findings of facts of the investigating prosecutor, and then he will forward the resolution together with the records of the case to the higher ups, the provincial prosecutor, the city prosecutor, the chief state prosecutor, or to the ombudsman in cases of what? In cases cognizable by the Sandigan Bayan in the exercise of its original jurisdiction. Now, they shall act on the resolution within 10 days from receipt thereof and shall immediately inform the parties of such action. Okay? Now, remember, class, that in case the investigating prosecutor will draft a resolution, that draft of the investigating prosecutor is merely recommendatory. Take note of that. Meaning it is not yet final. Because no complaint or information may be filed or dismissed by an investigating prosecutor without the prior written authority or approval of the provincial or city prosecutor or the chief state prosecutor or the ombudsman or his deputy. Now, since the resolution prepared by the investigating prosecutor is merely recommendatory, it needs the approval of the higher-ups, meaning the provincial prosecutor or the city prosecutor, as the case may be, etc., etc. Without the approval of this higher authority, that resolution will not take its legal effect. It will not take its legal effect. Now, are there cases wherein there can be no approval by the higher authority? Yes. If the higher authority, meaning the provincial prosecutor or the city prosecutor, will delegate the authority of approval of a resolution, then that delegation must be done in a prior written authority. In other words, the higher authority can delegate to the deputy prosecutors, for example, the authority or the power to approve, no, to approve the resolution prepared by the investigating prosecutor. So it works both ways. It's either that the resolution prepared by the investigating prosecutor is approved by the provincial or city prosecutor, or if it does not, if the prosecutor will delegate the authority through a written delegation, prior written delegation, then the deputy prosecutor, deputy provincial prosecutor, or deputy city prosecutor can approve the filing of a resolution or information in court. Okay. Now, what in case that there is a different findings between the investigating prosecutor and the superior prosecutor? What happens? Now, when the investigating prosecutor recommends the dismissal of the complaint, but his findings are reversed by the superior quote-unquote prosecutor or the ombudsman on the ground that probable cause exists, the superior prosecutor or ombudsman may by himself file the information against the respondent or direct another assistant prosecutor to do so without conducting another preliminary investigation. In other words, class, if the investigating prosecutor finds no reason to hold the respondent for trial, meaning to elevate the case to the courts, then he will recommend the dismissal of the complaint. However, since that resolution recommending the dismissal of the complaint is merely recommendatory, the superior authority can reverse the findings of the investigating prosecutor and direct the investigating prosecutor to file an information in court without the need of conducting preliminary investigation. In other words, the higher authority can reverse the findings of the investigating prosecutor and order him to file the information in court. Now, what is the remedy of the aggrieved party from the resolution of the investigating prosecutor? So, for example, if the complaint has been dismissed, the complainant can exercise some remedies. Now, what is the remedy left of the losing party or the aggrieved party from the resolution of the investigating prosecutor. An aggrieved party may appeal by filing a verified petition for review with the Secretary of Justice and by furnishing copies thereof to the adverse party and the prosecution office issuing the appealed resolution. Take note, class, that in case you lost your case in the city prosecutor or the provincial prosecutor, what is your remedy? You file a verified petition for review. And where do you file the verified petition for review? You file it with the Secretary of Justice. And you have to furnish copy of your petition to the adverse party and the prosecution office whose resolution is being assailed. No? The appeal shall be taken within 15 days from receipt of the resolution or the denial of the motion for reconsideration or reinvestigation if one has been filed within 15 days from receipt of the assailed resolution. Only one motion for reconsideration is allowed. Now, the second bullet in your screens will tell you about the period of time within which you can file your petition for review. You can file it 15 days from the date of receipt of the resolution, or if you file a motion for reconsideration, the 15 days will be counted from the receipt of the resolution denying your motion for reconsideration or motion for investigation. Okay? Unless the Secretary directs otherwise, the appeal shall not stay the filing of the corresponding information in court on the basis of the finding of probable cause in the assailed decision. Now, if, for example, you lost your case in the prosecutor's office and then you file a petition for review to the Secretary of Justice, will your petition review has the effect of suspending the filing of the information in court? Answer: no, it will not. Even if you have elevated the matter on appeal, the filing of the information in court is not suspended. Meaning, even if you appealed your case to the Secretary of Justice, it will not suspend the filing of the information in court. Okay? Now, the decision of the prosecutor may be reviewed by the courts when he acts with grave abuse of discretion amounting to lack of jurisdiction. Okay. So that is the procedure. Huh? The investigating prosecutor will issue a resolution. Okay. And then he shall forward the resolution together with the records of the case to the higher authority, the provincial prosecutor or the city prosecutor. And then the city prosecutor has the power to reverse the findings of the investigating prosecutor, and he can direct the investigating prosecutor to file the information in case there is a resolution of denial. No? And then if you lost your case in the prosecutor level, you can go up through a petition for review, a verified petition for review. Class, ano bang ibig sabihin ng verified petition for review? Meaning, the complainant or the respondent or the parties to the case must have to sign the petition for review. No, when you say verification, the party has read the contents of the petition and that the allegations therein are true and correct based on personal knowledge or on authentic records. That is what we mean by verification. Okay. Now, what happens when you elevate the case to the Secretary of Justice? The Secretary of Justice may motu proprio reverse or modify the resolution of the provincial or city prosecutor or chief state prosecutor. The Secretary of Justice may review resolutions of his subordinates in criminal cases despite the information being filed in court. Now, if the provincial or city prosecutor can reverse the investigating prosecutor, the Secretary of Justice class can also reverse or modify the resolution of the provincial or city prosecutor or chief state prosecutor. No? It can review the resolution of his subordinates, no? Even if the cases are filed in court. Now, what happens if the Secretary of Justice will order the dismissal of the case? Will the order of the Secretary of Justice binding in courts of law? Answer no. No? The Secretary of Justice may not order the court to dismiss the case even if he finds the absence of probable cause. Hindi niya pwedeng salungatin ang husgado. Only the courts of law will have exclusive power as to the disposition of the case. Pag sinabi ng husgado, kahit sinabi ng prosecutor's office na walang probable cause, pag sinabi ng court na may probable cause, the court will prevail. Because once the information is filed in court, the court has exclusive discretion, has exclusive authority to dispose of the case. No? Okay. Okay. Now, in case that you lost your case in the Secretary of Justice, what is your remedy? You can appeal your case before the office of the President, and that in case that you appealed, so Secretary of Justice, you can appeal to the office of the President, and if you lose with the office of the President, the decision of the office of the President may be appealed before the Court of Appeals pursuant to Rule 43 of the Rules of Court. So yan ang hierarchy class. City Prosecutor's Office. Natalo ka, appeal ka sa Secretary of Justice sa DOJ. Natalo ka, appeal ka sa OP, Office of the President. Natalo ka rin, mag-Rule 43 ka, no, to the Court of Appeals. This is the hierarchy in preliminary investigation. However, if there is grave abuse of discretion amounting to lack or excess of jurisdiction, a petition for certiorari under Rule 65 may be filed. Okay. Now, take note, class, that the resolution of the ombudsman in administrative cases may be subject of a petition for review under Rule 43 of the Rules of Court before the Court of Appeals, or a special civil action for certiorari through Rule 65 before the Supreme Court in criminal cases. Take note of that. Kasi class, ang ombudsman, they are the special prosecutors. No? When you say special prosecutors, they are only assigned in violation of 3019, Anti-Graft and Corrupt Practices Act, the violation of the plunder law, no, commission of crimes by a public official with a salary grade of 27 or higher, and jurisdiction niyan, class, is with the office of the ombudsman, hindi sa regular prosecutor. No, halimbawa, you lost your case in the ombudsman, yung ombudsman, final niya yung resolution and information sa Sandigan Bayan, no, the court which tries yung mga violation of 319, Anti-Graft and Corrupt Practices Act. No, ang remedy mo, depende. Kung admin case ang hinawakan ng ombudsman, ang remedy mo, saan mo ifa-file? Sa Court of Appeals. Anong ifa-file mo? Rule 43, Petition for Review. What if criminal case ang hinawakan ng Office of the Ombudsman? Natalo ka. What is remedy? Petition on certiorari. No, petition for certiorari under Rule 65. So depende. Kung admin case, what you file is Rule 43, Petition for Review. You file it with the Court of Appeals. If it is a criminal case, you file it before the Supreme Court. And then what you file is petition for certiorari under Rule 65 of the Rules of Court. Okay. Now, what is the effect of the filing of the petition for review before the Department of Justice if the information was filed in court? So, for example, natalo ka sa prosecutor level. No, natalo ka sa city prosecutor or sa provincial prosecutor. Talo ka dyan. And then, umakyat ka sa DOJ, petition for review. No? Ano ang effect niyan sa proceedings ng husgado? Kasi in the meantime, natalo ka doon, inapila mo, final ng information sa court, dire-diretso na yan. Arraignment, pre-trial, and then trial. In the meantime, nakabinbin yung apila mo sa Secretary of Justice. So what is the effect of the filing of a petition for review if the information was already filed in court? Now, should the information be already filed in court, but the accused filed a petition for review of the findings of the prosecutors with the Department of Justice, the court is bound to suspend the arraignment of the accused for a period not exceeding 60 days. So you are entitled to a suspension of the arraignment for a period of 60 days, but it cannot be longer than 60 days. Okay. Okay, let us go to arrest. So after preliminary investigation, class, final na si information in court, and then the court will now determine probable cause. No? If the accused um, must be held must be brought before the custody of the law. Yan ang ibig sabihin niyan, probable cause. Now, upon receipt of the court of the resolution, the information, and the records of the case, within 10 days from the filing of the complaint or information, the judge shall personally evaluate the resolution of the prosecutor. No? I-assess niya, meron bang batayan itong reklamong ito? Meron bang ebidensya? No? In conducting the evaluation of the resolution, the judge shall look into supporting evidence. So the judge will have to make a personal assessment of the complaint. The judge may not rely on the basis of the resolution or complaint. He has to see it for himself. The judge will have to satisfy if there is really a ground for the issuance of a warrant of arrest. Now, there are two options of the judge upon the filing of the information. Number one, the judge can dismiss the case if the evidence on record clearly failed to establish probable cause. Kung walang ebidensya, class, dismiss. No. Now, if he or she finds probable cause, the judge may issue a warrant of arrest or issue a commitment order of the accused. If the accused had already been arrested pursuant to a warrant of arrest or lawful arrest without warrant. Okay. Third, in case of doubt as to the existence of probable cause, the court may order the prosecutor to present additional evidence within 5 days from notice. The issue to be resolved is that the issue will be to be resolved by the court within 30 days from the time of the filing of the information. So there are three options of the judge in case he receives the information. Now, he will make a personal evaluation of the complaint and the evidence adduced by the complainant and his witnesses. Now, if there is no enough evidence, he can dismiss the case outright. If there is evidence, he can issue a warrant of arrest. But if the accused had already been arrested, what the court will issue is not a warrant of arrest, but a commitment order. No? If the accused had been arrested pursuant to a warrant of arrest or lawful arrest without warrant or warrantless arrest. Now, in case there is a doubt in the mind of the judge whether a probable cause exists, then he can order the prosecutor to present additional evidence within 5 days, and that must be resolved within 30 days from the time of the filing of the information. Now, what are the cases which do not require preliminary investigation? No? Number one, when the penalty prescribed by law for the offense involves an imprisonment of less than 4 years, 2 months, and 1 day. We have said this, no? If the penalty of imprisonment imposable is less than 4 years, 1 day, 4 years, 2 months, and 1 day, meaning 4 years and 2 months and below, these do not require preliminary investigation. No, tandaan niyo yan. Now, if a person is arrested lawfully without a warrant involving an offense which requires preliminary investigation, an information or complaint may be filed against him without the need of preliminary investigation, provided an inquest had been conducted in accordance with the existing rule. Yan yung mga tinatawag na mga warrantless arrest. Now, if a person has been arrested without a warrant of arrest, then you do not conduct preliminary investigation. What do you conduct? Inquest. Kasi nahuli siya without a warrant of arrest. No, it is a circumstance of a lawful or a valid warrantless arrest. So you do not go to preliminary investigation. Instead, you go to inquest. Thus, if a person is arrested by a police officer in flagrante delicto or caught in the act while robbing the victim, the arrest is a lawful one, and a preliminary investigation is not required even if the penalty for robbery is more than 4 years, 2 months, and 1 day. So take note of that. Now, how do you institute cases when preliminary investigation is not required? Kasi class, under ordinary circumstances, you file your complaint before the city prosecutor or provincial prosecutor as the case may be. Now, if the case does not require preliminary investigation, what is the procedure? How do you institute the case? First, you can file the complaint directly with the prosecutor. Note, the prosecutor shall act on the complaint based on the affidavits and other supporting documents submitted by the complainant within 10 days from its filing. And number two, you can file the complaint or information directly with the municipal trial court. Okay. Okay. Now, what are the instances when amendment of an information does not warrant a new preliminary investigation? No? So for example, there is an error in the information and you have corrected that error. Does it require a preliminary investigation? It depends. So these are the instances wherein amendment of the information will not warrant a preliminary investigation. Number one, amended to information is not substantial. Number two, the court orders the filing of correct information involving cognate offense. Number three, if the crime originally charged is related to the amended charge, such that an inquiry into the new one would elicit substantially the same facts that an inquiry to another would reveal. So these are instances where even if you amend or you change, you edit or you revise the information, no, it will not require a new preliminary investigation. No, these are the three instances. On the other hand, these instances of amendment of an information will require a new preliminary investigation. One, if the amendment of the information changes the nature of the crime charge, or when on its face the information is null and void for lack of authority to file the same and cannot be cured or revived by mere amendment. Now, class, for example, we said earlier that before a resolution or an information is filed in court, it must be approved by the higher or superior authority, just like the provincial or city prosecutor. Now, in case that the person who approves the filing of the information is merely the deputy city prosecutor or deputy provincial prosecutor without the prior written authority delegating the authority to approve the information, then the information is null and void because it lacks the authority of the person to approve the same. Now, if the on its face of the information, it is null and void because it was approved by a person who does not have an authority to file a resolution, then you cannot just merely amend the information. You have to conduct another preliminary investigation. That is what we mean by paragraph 2. Okay. Now, what are the remedies of the accused if there was no preliminary investigation? The accused can ask for preliminary investigation before he enters his plea. The court shall resolve the matter as early as practicable but not later than the start of the trial. Okay? Failure to invoke the right before entering a plea will amount to a waiver. Okay. Now, let us go to inquest. What is inquest? Inquest is an informal and summary investigation conducted by a public prosecutor in criminal cases. involving persons arrested and detained without the benefit of a warrant of arrest issued by the court for the purpose of determining whether or not said persons should remain under custody and correspondingly be charged in court. Now, what are the duties of the inquest officer? Shall recommend the release of the person arrested or detained, or note down the disposition on the referral document. Okay. Now, the initial duty of the inquest officer is to determine if the arrest of the detained person was valid. Should the inquest officer find that the arrest was not made in accordance with the rule, he can recommend the release of the person. He shall prepare rather a brief memorandum indicating the reasons for the action taken and forward the same together with the record of the case to the city or provincial prosecutor for appropriate action. Okay, so who are the persons allowed to conduct the preliminary investigation? No, the preliminary investigation may be conducted by the inquest officer himself or by another assistant prosecutor to whom the case may be assigned by the city or provincial prosecutor, which investigation shall be terminated within 15 days from its inception. Okay. These are the matters included in a referral document in an inquest proceeding: affidavit of arrest, investigation report, the statement of the complainant and the witnesses, and other supporting evidence gathered by the police in the course of the latter's investigation of the criminal incident involving the arrested or detained person. Okay? And that the affidavit of arrest and statements, affidavits of the complainant and the witnesses must be subscribed. It must be under oath before the inquest officer. No, you as the arresting officer must subscribe an oath before the inquest officer. Okay. Now, what are the instances when the detained person uh, is dispensed with, or the production of the detained persons before the inquest officer is dispensed with? If he is confined in a hospital, if he is detained in place under maximum security, if production of the detained person will involve security risk, or if the presence of the detained person is not feasible by reason of age, health, sex, and other similar factors. Now, let us go to arrest. So before we go to arrest under Rule 113, let us take a short break first. Okay, let us continue on the Rule 113 arrest. Okay. Arrest is defined as the taking of a person into custody in order that he may be bound to answer for the commission of an offense. So when you say arrest, you take into custody, no? You take the person is taken into custody of the law so that he may be bound to answer for committing a crime. Okay? Now, who are the persons who cannot be subjected to arrest? One is senator or member of the House of Representatives shall, in all offenses punishable by not more than 6 years, okay, of imprisonment, be privileged from arrest while Congress is in session. So you cannot arrest a senator or a congressman if the imprisonment is not more than 6 years while Congress is in session. Now, under the generally accepted principles of international law, sovereign or other chiefs of state, ambassadors, ministers plenipotentiary, ministers resident, and charge of affair are immune from criminal jurisdiction of the country of their assignment and are therefore immune from arrest. So this is pursuant to the Vienna Convention. No? These are representatives of foreign states or foreign government. You cannot arrest them because they are immune from the criminal jurisdiction of the country. This is pursuant to a treaty obligation of the Philippines. Okay, the arrest of duly accredited ambassadors, public ministers of a foreign country, They're duly registered domestics subject to the principle of reciprocity. Okay? How do you make arrest? Arrest is made by actual restraint of a person to be arrested or by his submission to the custody of the person making arrest. So it's either voluntary surrender or the arresting officer putting an actual restraint of a person. Now, arrest may be made on any day and at any time of the day or night. No, it can be effected at a night time. No? Now, the head of the office to whom when the warrant was delivered must cause it to be executed within 10 days from its receipt. And the officers to whom it is assigned must make a report to the judge who issued the warrant within 10 days from the expiration of the period. If he fails to execute it, he shall state the reasons thereof. No? Okay, so this is the obligation of the arresting officer. You shall make a report, no, to the judge who issued the warrant of arrest within 10 days from the expiration of the period. No, within 10 days from the receipt of the warrant of arrest. If there is a failure to execute the warrant. Now, what are the instances when warrant of arrest is not necessary? If the accused is already under detention. Number two, a complaint or information was filed pursuant to a valid warrantless arrest because again, in this case, the accused is already under detention. And then complaint or information is for an offense penalized by a fine only. Multa lang ang babayaran, no? The offense has no penalty of imprisonment. Okay. Now, what are the instances of a valid warrantless arrest? Class, you have to memorize all of these enumerations. All of this. Huh? Please memorize. These are the instances of a valid warrantless arrest. Section 5, Rule 113. No? Please memorize. 1, 2, 3. Now, the first instance of a valid warrantless arrest. Ibig sabihin, class, even if there is no warrant of arrest, you can still effect arrest under any of these circumstances. Please, please, please memorize. No, memorize. Now, the first instance of a valid warrantless arrest is the so-called in flagrante delicto arrest. What do you mean by an in flagrante delicto arrest? When in the presence of the arresting person, the person to be arrested has committed, is actually committing, or is attempting to commit an offense. In flagrante delicto arrest. So this is the first instance. The requirement is that the commission of the crime must be done in the presence of the arresting person or the arresting officer. Now, what must have been done in the presence of the arresting person? The person to be arrested has committed, no? Nagawa na niya. Or is actually committing, ginagawa pa lang, or is attempting to commit an offense. In flagrante delicto arrest, no? Okay. So it's either that the offense has just been committed, kakagawa lang, no? Or the offense is being actually committed, or the offender is attempting to commit the offense, then you can effect arrest. Assuming that this commission is done in the presence of the arresting officer. This is the most important requirement. The fact that a person has just committed the crime, or the fact that the person is actually committing the crime, or the fact that the person is attempting to commit a crime must be done in the presence of the arresting person. No, dapat makita ninyo bago nyo arestuhin. Pag hindi nyo nakita, hindi nyo pwedeng arestuhin. Ano yung mga dapat nyong makita na ginagawa niya yung krimen? Or gagawin pa lang niya yung krimen? Or kakagawa pa lang ng krimen? Yan, pwede kayong mag-effect ng warrantless arrest. No? Now, when an offense has in fact been committed and the arresting person has probable cause to believe, based on personal knowledge of facts and circumstances, that the person to be arrested has committed it. This is the doctrine of hot pursuit. For example, you saw a person lying down in a blood bath, in a blood bath rather, and then you saw a person who is running away carrying a knife with blood in his hands. So this is an example of doctrine of hot pursuit because the offense has in fact been committed. It was kakagawa pa lang. And that there is a probable cause to believe based on personal knowledge of facts and circumstances that the person to be arrested has committed it. Yan ang example niyan, the doctrine of hot pursuit. And then third, you have to memorize this also, class. When the person to be arrested is a prisoner who has escaped from a penal establishment or a place where he is serving final judgment or temporarily confined while his case is pending or has escaped while being transferred from one confinement to another. So the third exception provides for an escapee in a penal institution. Now, if you have escaped from a penal institution, be it serving a final sentence or while your case is pending, then you can be arrested even without the benefit of a warrant of arrest. Otherwise, class, it's going to be highly impractical if you have seen a detained person or a detention prisoner, no, or a person, a convict serving his final sentence, leaving or escaping the penal institution. It is highly impractical for you to obtain a warrant of arrest because it will allow the escapee to what? To finally got out of control or beyond recovery or beyond the control of the penal institution. So in case there is an escapee, then you do not have to obtain a what? Warrant of arrest from the court. Now, again, these are the methods of arrest: actual restraint of the person to be arrested, or by his voluntary submission to the custody of the person making arrest. Now, arrest made by officer with a warrant. Amount of force to be used in making arrest. As a general rule, no violence or unnecessary force shall be used in making an arrest. Remember this, class. Please remember and bear it with your hearts. Do not use violence or unnecessary force in effecting arrest. The person arrested shall not be subjected to a greater restraint than that is what is necessary for his detention. In other words, if, for example, a person would already raise his hands and he has no weapon of any sort, then you do not have to employ unnecessary violence or force. Otherwise, it will amount to police brutality. No, take note of that. Now, exception to the general rule where violence or force is allowed if necessary to secure and detain the offender, overcome his resistance, prevent his escape, recapture him, and protect himself from bodily harm. But class, please do not abuse this authority given to you, no? Even if you are very certain that the person will not pose any bodily harm or risk to you, please do not use violence or unnecessary force. Otherwise, you will be violating the penal code. Okay? Okay. Now, an officer may break into a building or enclosure to effect an arrest provided that the person to be arrested is or is reasonably believed to be in the said building. The officer has announced his authority and the purpose for entering therein. He has requested and had been denied admittance. Okay? Object subject to confiscation from the person arrested. Objects subject of the offense or used or intended to be used in the commission of a crime. So, for example, in apprehension for dangerous drugs, so you seize, you confiscate the plastic sachet of alleged methamphetamine hydrochloride. But aside from the object, the contraband, what are the things that you need to confiscate as arresting officers? So those objects subject of the offense or used to in furtherance of the offense or is intended to be used in the commission of the offense, you can confiscate. Just like, for example, vehicle used to transport in illegal sale of drugs. The objects which are fruits of the crime, meaning, for example, in a bypass operation, the objects would pertain, the fruits of the crime would pertain to the bypass money. Okay. Those which might be used by the arrested person to commit violence or to escape, such as firearm, dangerous weapons, and those which may be used as evidence in the case. Okay. Now, class, in case that there is a valid arrest, then the arresting officer may conduct a search. Yan ang tinatawag na search in relation to a valid warrantless arrest. Now, search incidental to a valid warrantless arrest. Now, take note that the arrest must precede the search. In other words, the arrest must be effected first before the search. It should not be the other way around. No? If you conducted the search first and you have arrested a person on the basis of such a search, then the arrest would not be valid. And therefore, any and all evidence obtained in violation of the constitutional right of the person will be inadmissible evidence, in evidence. Now, nevertheless, a search substantially contemporaneous, meaning it is simultaneous, no, with an arrest can precede the arrest at the outset of the search. Reliable information alone is not sufficient to justify a warrantless arrest. So take note, class. For example, you have seen a bystander in a dark alley, no, walking to and fro the road and the dark alley, and then you notice that this person had been trying to hold something bulging in his stomach, which you suspected to be an unlicensed firearm. Now, you receive an information from the neighbor that the person is very suspicious, and what you did as police officers is to approach him and conduct a search. And when you conducted the search yielded to a firearm. What will you do? Because you believe that the firearm is unlicensed, no? What you did is to effect an arrest. Now, is that arrest valid? Answer no. The arrest must be effective first. It must be done prior to the search. It cannot be the other way around. Search for first before the arrest. No, it must be arrest and then search, not search and then arrest. Now, when you receive reliable information that a suspicious person is holding a bulging object in his stomach believed to be a loose firearm, then you cannot effect arrest on the basis alone of reliable information. You need to have a personal knowledge of the facts and circumstances that will constitute a reasonable belief that the person is committing a crime. If you do not have personal knowledge that a person is committing a crime, you cannot effect arrest. Otherwise, the arrest will be invalid and whatever evidence obtained therein will be inadmissible in evidence. And you can also be held liable, by the way, with illegal arrest. Okay. Arrest made by officer without warrant. As a general rule, no officer or person has the power or authority to arrest anyone without a warrant except those expressly authorized by law, such as in flagrante delicto arrest. So Section 5 of Rule 113, bypass operation, hot pursuit arrest, and then evasion of service of sentence by a detention prisoner, where a person who has been lawfully arrested escapes or is rescued by the bondsman for the purpose of surrendering the accused, where the accused out on bail attempts to leave the country without permission of the court. Okay, what are the elements of hot pursuit arrest? First, an offense has been committed. No, close proximity between the arrest and the time of the commission of the offense. No, hindi po pwedeng naglapse na yung several hours before the commission of the crime and the time of the arrest. Ang sabi ng Korte Suprema, there must be close proximity, no, between the arrest and the time of the commission of the offense. Second, the offense has just been committed and that there is a probable cause based on personal knowledge. Class, this is the most important element. The probable cause constituting the basis for the arrest must be based or must be called from personal knowledge. Dapat ikaw mismo ang nakakita, ikaw mismo nakarinig, hindi pwedeng nirelay lang sa'yo. The probable cause must be on the basis of personal knowledge on the part of the person making the arrest. Kayo, as arresting officer, kailangan meron kayong personal knowledge of facts or circumstances that a person to be arrested has committed it. Now, when you say personal knowledge, it means actual belief or reasonable grounds of suspicion that the person to be arrested is probably guilty of the offense based on actual facts. Class, tandaan nyo, actual belief. Hindi pwedeng presumption, hindi pwedeng assumption. Dapat ikaw mismo nakakita. No? Yan ang ibig sabihin ng personal knowledge. Personal knowledge has no reference to the actual commission of the crime, but to personal knowledge of the facts leading to probable cause. Okay, what is the obligation of the arresting officer after the warrantless arrest? The arresting officer must comply with the provisions of Article 125 of the Revised Penal Code. Otherwise, he may be held criminally liable for arbitrary detention under Article 124 of the Revised Penal Code. Jurisdiction over the person arrested of the person, no, must be transferred to the judicial authorities. Article 125 is a procedural requirement in case of warrantless arrest. A case must be filed in court. Now, what is the period for officers to deliver the person detained under Article 125 of the Revised Penal Code? Anong gagawin mo pag nakahuli ka? Yan ang ibig sabihin niya. The person must be delivered to the judicial authorities within the period specified under Article 125. Memorize Article 125. Article 125 is the delay in the delivery of detained persons to the proper judicial authorities. Kailangan magsampa ka ng kaso. Ngayon mo inaresto, bibilangin mo na yan. Yung oras na yan. Kailangan sa oras na yan, makapagsampa ka na ng kaso sa piskalya. No, what is the period of time? Depende sa penalty. If it is light penalty, then 12 hours from the time of arrest. Pag hindi ka nakademanda, hindi ka nakapagsampa ng kaso sa piskalya, within 12 hours, kailangan i-release mo na siya. Otherwise, you can be held liable again for arbitrary detention. Ha? Okay. Or Article 125, delay in the delivery of detained person to the proper judicial authorities. And then pag correctional penalty, you have 18 hours. And then afflictive or capital penalty, for example, reclusion, perpetua, or death, 36 hours from the time of arrest. So 12, 18, 36. Light penalty, correctional, afflictive, or capital penalty. Now, ratification of an illegal arrest. Illegality of warrantless arrest may be cured by filing of an information in court and the subsequent issuance by the judge of a warrant of arrest. Once a person has been duly charged in court, he may no longer question his detention by petition for habeas corpus. His remedy is to quash the information and the warrant of arrest. Now, for example, a person has been duly charged in court, no? Pursuant to an illegal warrantless arrest, what do? You file a motion to quash information or to motion to quash the warrant of arrest because there was illegality in the arrest of the person. No? Consequences of illegal arrest. The documents, things, or articles seized following the illegal arrest are inadmissible in evidence. No? If in case that there was illegal arrest, then any and all evidence obtained are are inadmissible in evidence. The arresting person may be held criminally liable for illegal arrest under Article 269 of the Revised Penal Code. An arresting officer may be held civilly liable for damages under Article 32 of the New Civil Code, and he may also be administratively liable. Now, can a private person perform or effect an arrest? Yes. When in his presence, the person to be arrested has committed, is actually committing, or is attempting to commit an offense. When an offense has just been committed and he has probable cause to believe, based on personal knowledge of facts and circumstances, that the person to be arrested has committed it and escapee from a penal estate. In other words, class, the instances of a valid warrantless arrest. Now, a private person can effect an arrest. Now, what is a warrant of arrest? It is a legal process issued by a competent authority directing the arrest of a person or persons upon grounds stated therein. So these are the requisites of a valid warrant of arrest. Now, only the judge can issue warrant of arrest. No? Okay. Now, what are the essential requisites of a valid warrant of arrest? Number one, it must be issued upon probable cause. No, probable cause is to be personally determined by the judge after examination under oath of the complainant and the witnesses he may produce. The judge must personally evaluate the report of the prosecutor and the evidence adduced during preliminary investigation. The warrant must particularly describe the person to be arrested and must be in connection with specific offense or a crime. Now, what is the period of the validity of a warrant of arrest? There is no time limit fixed for the validity of a warrant of arrest, unlike in a search warrant, which is effective only for 10 days. So, lifetime, no? There is no time limit. A warrant of arrest is effective, no, unless it is revoked by the court which issued such warrant of arrest. Okay? Now, unlike in a search warrant, it is effective only for how many days? 10 days from issuance. Now, it means that a warrant of arrest remains valid unless arrest is effected or the warrant is lifted. Now, if there was an improper issuance of a warrant of arrest, the proper remedy is to file a petition to quash the warrant of arrest, not a petition for habeas corpus, since the court in the latter case may only order release but not enjoin the further prosecution or preliminary examination of the accused. So what is the remedy? File a petition to quash the warrant of arrest. Now, determination of probable cause for the issuance of warrant of arrest. So class, magkaiba kasi ang definition ng probable cause for the purpose of the filing of information in court and probable cause for the purpose of issuance of warrant of arrest. So this is the definition for the latter. Now, probable cause means that facts and circumstances which would lead a reasonable, discreet, and prudent man to believe that an offense has been committed by the persons involved. It need not be based on clear and convincing evidence of guilt. Neither is it based on evidence establishing guilt beyond reasonable doubt or evidence establishing absolute certainty of guilt. Now, within 10 days from the filing of the complaint or information, the judge shall personally evaluate the resolution of the prosecutor and its supporting evidence, and he may immediately dismiss the case if the evidence on record clearly fails to establish probable cause. In case of doubt in the existence of probable cause, the judge may order the prosecutor to present additional evidence within 5 days from notice, and that issue must be resolved within 30 days from the filing of the complaint or information. If he finds probable cause, he shall issue a warrant of arrest or a commitment order in case that the accused had already been detained. Okay. So what are the distinctions of probable cause from the prosecutor to that of a judge? So sa prosecutor level, ang definition ng probable cause, ang purpose ng probable cause is for the filing of the information in court. No? On the other hand, with the judge, the definition of probable cause is for the issuance of warrant of arrest. No? Whether there is a necessity placing the accused immediate custody in order not to frustrate the ends of justice. Now, probable cause with the office of the prosecutor is an executive function, while that of the judge is a judicial function. Okay, so that ends our discussion. I'll see you again next meeting. Thank you for listening.